It's been just a few weeks since the news dropped. Still, the ripples are everywhere. People are still talking and trying to understand what this really means for gun owners. If you've been keeping up even a little bit, then you already know what I'm talking about. The major piece of legislation signed into law earlier this month. It's one of those once-in-a-decade moments that actually changes something. Not talks about change, not just lip service or hopeful speculation, but a real signature, a real law, and real consequences, for better or worse. The date was July 4th, 2025. No, seriously, that's when it was signed. Talk about symbolism. On Independence Day, a bill eliminated the $200 tax on suppressors, short-barreled firearms, and AOWs. If you had told me this was going to happen just 6 months ago, I would have laughed. Not a cynical laugh, but the kind of laugh that says, yeah, right, dream on. But here we are. It's real. It's in the books. The tax is gone. You still need to go through the forms and approvals, but now the tax is gone. That's not nothing. Now, before we all start celebrating like it's over, let's get something straight. This isn't the finish line. It's not even close. It's a good step, a really good step, but it's not the full repeal. We're not living in some NFA-free utopia yet. The registry is still there. The approvals are still required. You don't get to skip that part. Not yet. And that's where things get complicated. Because if you've been paying attention to the legal angle, you probably saw this coming. When the tax was removed, it left the entire structure of the NFA wobbling on a very narrow legal justification. You see, for decades, the NFA has stood mostly because of its taxation foundation. That's how they kept it alive through all the challenges. It's not regulation, they said. It's just a tax. Courts mostly agreed with that view, especially in a 1937 Supreme Court case called Sunzinski v. United States, where the justices upheld the NFA as a constitutional exercise of Congress's power to tax. They ruled that as long as the measure operated as a tax and wasn't inherently punitive, it didn't matter if the law had regulatory effects. That case became a cornerstone, cited again and again whenever someone tried to knock the NFA down. And for a long time, that justification worked, because the Constitution does give Congress the power to tax. End of story. But what happens when that tax is $0? What happens when it doesn't raise revenue, doesn't function as a tax, and yet the whole regulatory burden still stands? That's the million-dollar question. That's the question at the heart of a new lawsuit filed shortly after the bill was signed. Gun rights groups didn't waste any time. They were ready. They were waiting. As soon as the ink dried, the filing was submitted. And this isn't a random solo act. Major legal groups filed a focused lawsuit targeting the NFA's authority. It's the kind of challenge that's been building quietly for years. And the truth is, it couldn't have happened without this new law. The groundwork had to be laid first. The timing had to be right. And now that the tax is gone, the argument shifts from whether Congress has the power to tax certain weapons to whether they have any power at all to enforce these requirements in the absence of a tax. That's not just legal hair-splitting. That's a foundational question. If courts agree the NFA relies on tax authority, the registry could be dismantled. It doesn't mean it's going to happen tomorrow or next month or even next year. These things move slowly. But the door is open now in a way that it simply wasn't before. And that's why the timing of all this is so important. We're not just talking about a symbolic win or a headline-grabbing move. We're talking about a tactical shift. A moment where one side made a big push, and the other side had the follow-up ready to go. So, what does that mean for regular people? The folks who maybe have been holding off on getting a suppressor or building an SBR because the tax was just too much of a pain? Well, the simple version is this. You can now go through the process without paying the $200. That doesn't mean you skip the background checks or the paperwork, but the barrier is lower now, significantly. There's already chatter about how many new applications are flooding in. Some folks are rushing to submit Form 1s before the next shoe drops. Others are taking a wait-and-see approach, hoping the courts knock the whole thing down in a year or two. And honestly, both strategies make sense depending on how risk-averse you are. You've got people saying this is the beginning of the end for the NFA. You've got others saying the system will adapt, that the ATF will find new ways to justify what they're doing. Maybe they'll argue that the registry itself serves a purpose beyond taxation. Maybe they'll try to reframe it under some other power Congress has, interstate commerce, perhaps, or maybe national security. Don't underestimate the creativity of agencies that really want to keep their tools. But here's the thing. When the law changes, even in a small way, it invites review. It invites scrutiny. And that's exactly what's happening now. The lawsuit is already getting traction. Legal scholars are debating it. Gun control advocates are panicking. And gun rights supporters are cautiously optimistic. We've seen this kind of legal momentum before. Bruin was a moment like that. Heller was a moment like that. And while this new law doesn't carry the same weight as a Supreme Court ruling, it creates the kind of legal landscape where real challenges can be mounted and possibly succeed. The legal theory underpinning the lawsuit is both straightforward and strategic. It's not a shotgun approach with a dozen different claims hoping one sticks. It's narrow, focused, and built around a single concept. If the NFA is only constitutional under Congress's taxing power, and if there is now no tax, then the constitutional justification no longer holds. Without that foundation, everything built on top of it should, in theory, collapse. Of course, things are rarely that clean in real-world litigation. The government will fight this with every argument they can dig up. They'll point to precedent. They'll point to administrative necessity. They'll talk about public safety. And you can bet they'll lean heavily on the idea that removing the tax doesn't remove the underlying regulatory authority. They'll say it's about more than money. It's about national interest, about order, about oversight. But whether the courts agree is another story. The lawsuit itself was filed in a very deliberate way. The jurisdiction was chosen carefully. It's being brought in a district known for its friendliness towards Second Amendment arguments. The plaintiffs include both individuals and businesses, from average gun owners to well-known retailers and manufacturers. This isn't just about rights in the abstract. It's about real people facing real restrictions and burdens because of a structure that may no longer be constitutionally valid. As expected, the complaint cites previous cases from the 1930s, especially Sonzinski v. United States, decided in 1937. That case affirmed that the NFA could be considered a valid tax measure, even if its practical outcome was heavy regulation. The court stated that it wasn't their place to judge Congress's motives as long as the law functioned as a tax. But the new lawsuit argues that this reasoning no longer holds water. When the transfer tax was reduced to zero, the NFA stopped functioning as a tax altogether. The financial component disappeared, and what remains is a regulatory structure without a constitutional hook. And unless the court is willing to invent an entirely new justification out of thin air, the plaintiffs argue that the NFA can't stand in its current form. If the court agrees, the result could be historic. Even partial court agreement could lead to major changes. It could mean shorter wait times. It could mean fewer categories subject to regulation. It could force the ATF to overhaul its systems, redefine its scope, or even back off entirely on some enforcement actions. Any of that would be a win, especially for the millions of gun owners who have felt like they've been stuck under a system that doesn't respect their rights. At the same time, it's worth remembering that legal victories don't always come quickly. This case is just getting started. There will be motions, hearings, responses, appeals. A final ruling may take years, even without delays or appeals. But the important part is that it's happening. The challenge is real. It's out there now, and it's forcing everyone to pay attention. In the meantime, the practical question becomes, what do you do now if you've been on the fence about NFA items? There's no single answer. Some people are jumping in now, figuring that $0 is too good to pass up. Others are worried the process could be reversed, or that the ATF might retaliate in some obscure bureaucratic way. That fear isn't unfounded. The agency isn't known for its flexibility or friendliness. Still, for those willing to take the plunge, this moment is unique. For the first time in generations, the cost barrier has been removed. That's not a minor detail. That opens the door to entire segments of the community that were priced out before. People who couldn't justify the extra $200 for what was already a heavily controlled item. That access is real. It's tangible. And unless something changes fast, it's here to stay for the foreseeable future. And yet, the sense of uncertainty still hangs in the air. Because as much as this feels like a victory, no one knows what the government's next move will be. They could try to reinstate the tax under a different bill. They could propose a new regulatory framework. They could double down on enforcement elsewhere. Or they could just wait, hoping the lawsuit fizzles out and the public loses interest. It wouldn't be the first time. That's a tactic as old as politics itself. One thing's for sure, though, this is energized people. The response hasn't been passive. It hasn't been quiet. Gun owners are watching, they're organizing, they're showing up, and whether they're filing paperwork, joining legal groups, or just spreading the word, the sense of momentum is unmistakable. This isn't just about suppressors or short barrels. It's about what kind of regulatory power the federal government can use and where the limits really are. This moment, right now, in the summer of 2025, is going to be studied for a long time. Years from now, people will look back and say, this was when things shifted. Not overnight, not dramatically, but in a way that mattered, in a way that changed the trajectory of gun law in the United States. Whether you agree or disagree with that direction, there's no denying the significance. For those who have been involved in gun policy for a long time, this moment brings a strange mix of emotions. Relief that something finally changed. Suspicion that it might not last. Excitement at the possibilities ahead. Frustration that it took this long. And above all, a kind of cautious hope. Hope that this isn't just a one-off win. Hope that it signals a broader shift, one that respects rights without unnecessary delay, cost, or bureaucracy. In private conversations, some of the people behind the lawsuit have admitted that the next steps are unpredictable. Even with a strong legal theory and a favorable jurisdiction, it's hard to know how the courts will respond. Judges interpret things differently. Precedent can be both a shield and a weapon, and while the Constitution is the ultimate authority, the way it's interpreted often depends on timing, context, and politics. That's part of why this moment feels so delicate. The legal challenge is serious, but it's also vulnerable. A poorly timed ruling, a change in political leadership, or a shift in public opinion could throw everything off balance. That's not paranoia. That's just how the system works. Progress is real, but it's never guaranteed. Still, even if this new challenge, officially filed as case number 6.25CV0056H in the Northern District of Texas, doesn't immediately bring down the entire NFA framework, it's already changed the landscape. Just the act of filing it, backed by serious plaintiffs and experienced legal teams, puts pressure on the entire system. It forces a conversation, not just about taxes and forms, but about what authority the government really has when the financial justification is gone. Whether or not this case succeeds on every count, it marks a shift in how these laws are going to be challenged from now on. The tax removal alone is a material benefit to gun owners. And more than that, it breaks the illusion that the NFA is untouchable. It shows that reform is possible, that political will exists, that the courts are listening, and that, sometimes, the needle can actually move. The cultural impact of this shift is already being felt. Across the country, conversations around gun ownership are changing. The old arguments about cost and accessibility are fading. The stigma around certain types of firearms is eroding. People who never considered owning a suppressor are now filing forms. Builders and hobbyists who once stayed away from SBRs are finally entering the space. And those who were always involved feel like the rules of the game are finally starting to change in their favor. This isn't to say the debate is over. Far from it. Every gain invites pushback. There will be new bills proposed, some aiming to undo the progress, others trying to go even further. There will be state-level reactions, attempts to limit what the federal government has loosened. The conversation will continue, loud and polarized as ever. But the terms of that conversation have shifted, and that matters. For the agencies tasked with enforcing these laws, the next few months will be critical. They'll need to figure out how to operate under this new legal and political reality. Some may try to maintain the status quo as much as possible. Others may begin adjusting policies in anticipation of further change. Expect agency memos, clarifications, and internal friction as bureaucracy adjusts. For legislators, especially those who supported the bill, this is a test of follow-through. It's one thing to vote for a tax cut. It's another to defend it, to explain it to constituents, to stand by it when the media backlash begins. But for now, at least, they have a win they can point to. A win that means something concrete. A win that affects people's lives. In the end, what comes next depends on all of us. The courts will rule, yes. The agencies will respond. But the broader public has a role, too. To stay informed, to stay engaged, to keep the pressure on. Change doesn't just happen because a judge signs a paper or a politician gives a speech. It happens because people care enough to make it happen, because they show up, they write letters, they vote, they tell the stories that make the stakes real. So, whether you're someone who's been involved in this fight for decades or someone who just found out last week that the tax is gone, your role matters. This moment matters. What we do now could shape the next 10 or 20 years of gun law in this country. And that's not exaggeration. That's the reality of political and legal momentum. If you've been thinking about getting involved, this is your moment. Whether joining a group or talking with others, it all adds up. It all matters. No one person can move the mountain alone. But together, piece by piece, it can be done. Maybe one day we'll look back at this summer as the moment when everything started to shift. The time the conversation changed, the time the door finally opened. We'll see where it goes. But one thing's certain. It's not over. Not by a long shot.